without any restrictions, in as much as, of course, there are some small applications or perhaps applications that are vital?
Where the international law allows, yes. Like the Besigye case has also moved to the Jumuiya. Yeah. The East African Law Society has taken the matter of denial of a license to me by the Uganda Law Council to the Jumuiya. Yes. They've also taken up with the states their failure to enact and operationalize certain sections of the East Africa Community Foundational Statute to enable free movement of goods and people and professionals within the community. We can't take certain matters if we feel aggrieved to the African court. We can't go beyond that if we feel there are matters that affect us or our client, even to the International Court of Justice.
And you have yourself
presented. The limit
is
endless.
Yes, yes. You have presented cases at the East African.
In fact, I have an active case relating to the 2022 election. Yeah. It's pending.
Do you suppose there's any element of progress? So again, it's a typical classic example of what plays out back at home.
No, the East African Court does process their cases. If you remember, my 2018 and 2019 appeals were heard very expeditiously. Right. But the East African states have been starving the court of money to almost grind them to a halt. But the court is now active once again. That's how come the 2022 case has yet to be heard. That court does process things record time. And what that court does is affirm the rights of the people. Like in my 2018, 2019 cases, they were able to pronounce themselves that I did not get justice in the Kenyan court, and especially up to the Supreme Court. So that was egg on the face of the Supreme Court. Yes. The Supreme Court surreptitiously this year, or rather, shall I say, the AG's office took an advisory, seeking an advisory whether they are bound. And the Supreme Court, in self-preservation, made a funny ruling, and I'm calling it funny without batting an eyelid, because in jurisprudence, it is self-protection, self-preservation, making a ruling that the court, they are not bound and the AG is not bound by the decision. Treaties are a political act. You assenting to the treaty is political. The same Attorney General advised Kenya to assent to the EAC treaty. If they want to get out of it, it's a political act, not through an advisory that defies any known jurisprudence. So the Supreme Court has been a great disappointment to that extent. And the AG has been nothing but mischievous in that regard.
All right, the international community then is observing.